So good evening, everyone. What a pleasure it is to see you all in person. After 2 years of seeing you all in yellow square boxes, this really makes a huge difference. And we're quite happy to be doing one of our first live events here at our Midtown facilities at the Central Park Room, which is actually one of the largest rooms we have here. So very happy that you all could join us. Tonight, we're going to be discussing legal research, publication of international awards. In general, what information is actually out there? You know, we do have responsibilities as administrators about confidentiality, but the need for transparency, people searching for data, people wanting to know what goes on in international arbitration has to be balanced against the need for confidentiality. And that is what this distinguished panel is going to be discussing here today. We also have the authors of the ICDR Guide to the International Arbitration Rules. They're going to provide their perspective on the research they did and the transparency and what's out there about the ICDR processes and systems. So it's going to be a very informative debate and discussion. I do want to take a moment to thank our sponsors, Chaffetz Lindsay's and Bracewell, for sponsoring tonight's event. Without them, it couldn't be possible. I want to thank NIAC for being a cooperative entity. And I also want to mention that this program is going to be recorded. We're going to put it on the ICDR Y&I site, which you may know has over 30 programs already there dealing with all different types of international arbitration. And if you'd like to join, the application is there. So I do invite you to do that when you can. So let me start off by introducing our moderator, Eric Tuckman, who many of you know. He's our Senior Vice President, General Counsel, and Corporate Secretary for the American Arbitration Association, and also heads up our international division, the ICDR. So with that, welcome, Eric, the floor is yours.
Thank you, Louis. And again, it is great to see everybody. We had our annual meeting of our board and council not so long ago, but we keep on going in waves with this with the coronavirus, of course, and tired of talking about it. But the fact is, we are living with it. We keep on adjusting to it. And I think the fact that all of you, that still takes a little bit of effort to get out, it seems. And we're really thrilled to have you all here today. I like today's topic because, frankly, it's different from some of the standard issues that we're talking and thinking about a lot. Of course, procedure, how we conduct our arbitrations, making sure they're fast, effective, that arbitrators have the right backgrounds and knowledge. Like all things technology related, in the past 20 years, of course, we've seen tremendous change. And the issues we're talking about today have been impacted as well. When we think about the amount of information, the amount of data that existed, again, if you just think back 15 years ago, if you wanted to know what the taxes were like, how much your friend paid for their home in Southern California, you've got to go down to Huntington Beach or LA County and flip through the court assessors, the tax assessors records, right? Of course, now that same exact information, you get it in a second, it's compiled in whatever form you want. You get this historical data for years and years and years. It's powerful. It's also dangerous. Of course, there's a component of this that relates to personal information. But of course, the point is, access to information, data, how it's available, how it's used, has been gone through tremendous change. It's gone through change with respect to arbitration and the legal field as well. But of course, a lot of us are still using Westlaw, despite the fact that a lot of other court decisions are publicly available throughout the world because they organize things in a way that's useful. We've been thinking a lot within the AAA and ICDR about what we do with our own data and what we do with awards. There's this tremendous tension. Making awards available, making information about arbitrations available, making information about arbitrators available is what parties want. That's what the users want. It's balanced against what the parties themselves want when they're in a case. And they're really not interested for reasons that may be appropriate, putting aside things like employment, consumer matters, and commercial matters. There are appropriate reasons not to want to have your arbitration award plastered all over the internet, or the New York Times, Wall Street Journal, whatever the case may be. But we have made a big movement towards the availability of awards, which is why we've put this program together today with Jus Mundi's involvement. And we're very excited about a partnership that we've entered into with them. And you're going to see and hear a lot about it. It's going to be very enticing. I think for those who haven't seen the platform, you're going to find it to be pretty compelling. So here to talk about the issues about awards, research, how you confidentiality, what party preferences are, and how they deal with those issues as parties and as arbitrators and as lawyers, is a panel of great friends of the ICDR and the AAA. Bill Crosby, Senior Vice President and Associate General Counsel at Parent Public Group in New York, is here. He is also a newly minted member of the AAA's board, I'm happy to say. Martin Goosey leads the arbitration practice in New York at Bracewell in New York. James Hosking, founding partner at Chaffetz Lindsay. Together, as Lewis mentioned, but it's important, James and Martin wrote the guide to the ICDR's rules, published by Oxford University Press. And Wendy Benoit, AAA ICDR council member from Cozen O'Connor in Boston. And then finally, Jean-Remy Desmestières, luckily for him, from Paris and New York, who is the CEO and co-founder of Jus Mundi. And with that, I will hand it over actually to John. Thank you.
Thank you, Eric. Thank you for the introduction and for the invitation. I have to say first that we are very proud of starting this collaboration with AAA ICDR, and we want to thank you for the trust that you put in Jus Mundi for working with you. I will so do a short presentation first about Jus Mundi, if you don't know us yet. I will explain a bit how the collaboration is working, and finally, I will present the benefits of this collaboration for the arbitration community by showing you how this data can be used on Jus Mundi. First, so about Jus Mundi, when we did the preparatory call of this, we were discussing that maybe what Jus Mundi is doing is not very new, that is already been existing. And I have to say that it is true. What we do is to provide a service for legal research, for professional research, I mean arbitrator research especially, and this has always existed. For centuries, we are looking for information in books, so there is nothing new here. But I believe there are new aspects in first why we do and why we have built Jus Mundi. Even if we are a business, we are also a mission-driven company. We built Jus Mundi because we believe that one day there will be a global rule of law, and that it is our shared responsibility as international lawyers to participate in building this global rule of law. And one of the ways to do it is to provide access to legal information. That's why we have a very unique model at Jus Mundi. All the primary sources that are available on our platform, for instance, awards, are freely accessible. You don't need any subscription to read them, download them, and use them as you want. Okay? What we sell is some technology that will help you to search more efficiently through this information. And I think that's one of the reasons institutions like to work with us, because the information is really made public. And we are probably also different in how we do that. We are not a publisher, we are a legal tech company. So by legal, I mean that first, we are former lawyers. I am myself, and 25% of our team, which is today 70 people, is composed of former arbitration lawyers. And then we are a tech company. 50% of our team is composed of engineers, especially people working in artificial intelligence, and I mean here natural language processing, which is the capacity to understand the text, to process the text, and I will show you some of these applications in 1 minute. We are quite young, from Paris, indeed, and we started Jus Mundi in 2019, first on investment arbitration, because as you all know, the data is more easily accessible. Then quickly we move to commercial. And first we have been told like, why do you do that? Because everything is confidential in commercial arbitration. Quickly, we could identify a lot of information. And so first, the database that we built, we did it by ourselves. We looked outside on some public databases like Pacer in the US, but there are some other in other countries. We look into a newspaper, some awards sometimes are leaked. We look also about information on cases. So if a company that is publicly listed says that they start an arbitration case, we will also collect this information and include it in our database. So we first aggregate what we could find by ourselves. Then to go further, we started to build partnerships. The first one that we did is with the International Bar Association. That's a collaborative network partnership. It allows lawyers all over the world to send us awards, commercial arbitration awards, that are not confidential anymore because they were not, or because they became public through an enforcement process. And in many jurisdictions, it helped us to identify awards that were complicated to identify from Paris. With this partnership, we collected more than 2,000 international commercial arbitration awards already. Then the next step for us was to start collaborating with institutions to help them to publish. So here I want to be very clear, when we collaborate with institutions, it's different. What we do by ourselves or through the IBA partnership, that's awards that become public and we publish them in full, okay? So you will find the full award with all the information. When we work with institutions, we will publish redacted award with parties agreement, okay? So that's a very important distinction. The first one that we did was in 2021 with ICC. And then Jus Mundi developed as a startup company. So we did a Series A funding in 2021 that allowed us to open an office in New York. That's why also I'm today between New York and Paris. And now the step that we are discussing today is this partnership with AAA ICDR that I will explain in 1 minute to tell you exactly how it works. Just to finish on Jus Mundi, if you wonder who is using Jus Mundi after as client, so first the free version of Jus Mundi is visited by 100,000 people every month that are mostly arbitration practitioners, but there are students, academics also, and all of that. And then people who are using the paid version of Jus Mundi are mostly lawyers, some big law firms, but also boutiques in more than 40 countries. Governments, the US State Department is one of them, and which is maybe more surprising to you, legal services of companies. And we see more and more of them, but they are not using us for the same reasons and lawyers, and we'll come to that in a moment. You can add a few experts and third-party funders, but it gives you the idea of who's using the platform. So let me now move to the partnership that that we are discussing today. So partnership between AAA ICDR and Jus Mundi. So this page is available online. You can take the time to read it if you wish. And there is a section that explains the how it works. So that should be on the first one. So the first step is to get parties agreement. So that's ICDR that will select some awards that first are interesting of our ICDR, mainly Louis' team, will select the awards that are interesting and that they believe that parties might accept to the publication. This award, we will redact it at Jus Mundi, and this is done under a very strict confidentiality agreement and under also a very high security. The first redaction is an automatic redaction that we have been able to automate it thanks to NLP, artificial intelligence, and this version will be submitted to parties. So the first redaction is quite basic. We remove name of parties, name of individuals. We will replace them by person 1, person 2, etc. And if parties agree, it will be published. In several cases, parties will say, oh, I might agree, but this is not enough for me. I want you to remove any information that can lead to my identification. So then we will go to a manual step. We will remove everything that will help to obtain parties agreement. Then it goes back to the parties, and once there is their agreement, was a step about anonymization. ICDR validates everything, stamps the award, and it is published on Jus Mundi and fully accessible to anyone. Okay, so if there are questions, I guess we can come back to that after. And oh yeah, to show you maybe how does it look after. So that's, for instance, an ICDR procedural order that was under the 25th of April, that we collected through the IBA partnership. So it is available like that on Jus Mundi with some information and the text of the award that you can see on the platform. Okay, so that's the end result. There is a PDF version also that is available. So now the third part of the presentation is to discuss the use cases that I mean, what's the usefulness of this award. So I will go through three of them. The main one that you of course expect is legal research. The second one, also that is not surprising, is arbitrator selection or counsel expert selection. And the third one is business intelligence, and it's probably more surprising to you. So for legal research, one of the topics that will come is about we believe that commercial arbitration awards will get a precedent value in the future. And I want to make the point that yes, they will. And I believe that in any legal system, it happens at a time. And I am French, I come from a civil law system. I used to practice in public international law, where also it is supposed to have no precedent value from awards or even court judgment, but there is one that developed because of two reasons. And I think the two necessary reasons to have such a system is to have first availability of information, and also a diversity of the cases that is not too big compared to the number of cases. Because if you have hundreds of cases, but it is so diverse, like in commercial arbitration, you can't refer to a precedent. And I think that's what is changing with now the increasing in availability of documents. And here, for instance, I did a research on Jus Mundi to search any case that discuss force majeure that are about shipping and with the application of New York law. So here we will start to have a case that will look very similar to the one you are working on. And you see that we find 6 awards that are only about these topics, including here one ICDR award. Okay? So this is an example, but we could do like a construction, even pipeline construction, and find some facts that are very similar. So you can, on the merit issue, find even cases that will look like yours. You can also select awards that are awarded by a specific arbitrator if you want to, if that's interesting. So that's for merit issue, but I want to show maybe a more consensual example, which is about interpretation of procedural issues. Another nice way to search information in Jus Mundi is to go on rules. Like here, for instance, we have the ICDR rules from 2014, and you can notice a little icon with a number on almost all Jus Mundi's documents, rules, awards, treaties, anything. This tells you the number of documents in our database that are applying this version of the rules. Okay? And you can narrow down to a specific article, like Article 2, or even Article 2, Paragraph 3. And then you can have access to the awards that are interpreting this specific article. So this is done, for instance, thanks to artificial intelligence. We have an algorithm that understands that this is a reference to the rule Article 2, Paragraph 4, and will implement here an hyperlink to these rules. Okay? So this you can have it for any arbitration rules for any article, and you can find interpretation of this article. That's the first use case, legal research. Of course, I could show you more inside the platform, but I think I'm already running out of time. So my second point is about arbitrator, counsel, or expert selection. There is another part in Jus Mundi that is called Jus Connect, in which you can search for people or firms or not for legal information. And here we can either type the name or we can use filters, like let's say that we want a US arbitrator who has experience with ICDR rules and also in mining cases. And we'll find a list of potential arbitrators that will appear. Oh no, and I want also someone with a speaking German. I want it. And for instance, I can find, oh, James Hosking profile here. That I will open. So what to tell you about this profile? First, this profile is an automatically generated profile from our database. So it means that James didn't do anything about it. And it means also that the quantity of information depends on our database. So it's not comprehensive, it's only what we know from James. But the also good part of it, and I believe what people come to find on Jus Mundi, is that it is neutral information. Okay, everything that is here at least is, but the cases it's validated, and you can trust that as a neutral source. On this page, you will see information for what we know about his role as an arbitrator, as a counsel, could be also expert. You have a summary. You have the work experience. Latest documents rendered by the tribunal in which James is sitting, some analytics about these cases, and finally the list of cases for arbitrator or counsel. Okay. So this is not complete. That's what I was saying, and it's information like experience, etc. Also, are information that have been extracted automatically from the database. But there is a possibility for arbitrators to take control of their profile. So I will take another example that you see, that you maybe know, Alexis Moore, and you see on Alexis' profile two differences. First, there is a picture, and second, there are a lot of cases, 88 cases, 86 as an arbitrator. So it's possible for arbitrators or counsel or experts to take ownership of their profile, to modify some part of the profile. It works like your LinkedIn. You can modify your work experience, etc. And so here for Alexis, the locations, the languages, the work experience, he has edited and put what he wants for this. But he also could submit to us some cases that we didn't know. Some cases that is allowed to submit with some basic information that are not confidential, like the name of the co-arbitrators. And our team has verified the information, meaning that we contacted the other co-arbitrators and asking for validation without saying who has given us the information. But we need 2 validations to be able to create the case. So I think we had something like 40 about Alexis before, and we could increase to 80 afterward. So this exists for counsel experts. I will not make you the same demonstration for this profile, but it works the same way. The other part, when you appoint someone, is to also avoid any conflict of interest. And to do that, you then go on Jus Mundi on what we call the conflict checker. And here you can put the name of 2 persons, or 1 person, 1 firm, 1 person, 1 state. We will add corporates also in a few weeks. And this will give you instantly the list of past or present relationship between this person. And I use this example. So with an expert case, maybe you know where I go with this example. So if we put Stanimir Alexandrov and Battle Group, we see a relationship between this person and this firm. And you can see instantly that there are a lot of cases where there were both either counsel or arbitrator appointed by one party, and also the experts were appointed in this case. And that's the reason why in the Heather versus Spain case, the award has been annulled because of conflict of interest between the expert and the arbitrator in this case. Okay, so this is very helpful to instantly see links between people. And very quickly, the last use case I was telling you about business intelligence. So we can, in our search engine, search for other information than legal information. You can search for any also business information. So if I look for Chevron, for instance, I will be able to find all the cases that discuss Chevron. And if there is, it's maybe Chevron, the US now Chevron, and if there is a new case that is starting involving Chevron and we know about it, this will appear here into the platform. So you can do this research, and then you can put what we call alerts on Jus Mundi. And by doing that, I already created, you will get a notification either in the platform or by email every time we have the new information that concerns this company. And so we have corporates that are using this to monitor themselves, to monitor their competitors, their market, their partners. We have experts that use us to monitor law firms' activity to offer them the services. So there are a new set of applications that we see developing now with this information available. That's all. Happy now to discuss this with you.
Very much. So I do want to clarify one thing. So the awards that are being made available, at least from us, relate to the cases that have been rendered, awards rendered under the international rules. In terms of domestic matters, that's not within the scope. But again, I think you can see this is a very powerful development and a very powerful database. And so as we're looking at a platform like Jus Mundi, they're pulling awards from the ICDR and AAA, frankly, in large numbers, just from publicly available sources. And so at least with respect to information which we're making available, we're doing it in a way that's consistent and responsible to ourselves and also to parties. But also just to explain at least what our own rules say about this, James Husking is going to add a little bit of additional commentary.
Thank you. Thanks, Eric. And just in case anyone's thinking of pointing me to as an arbitrator, I will not be submitting any awards to Jus Mundi.
Get it anyway.
If you want to challenge the award, go ahead. So just to provide a little bit of context for the partnership that has been described with ICDR's entered into with Jus Mundi. There was an amendment to the ICDR international rules in 2021, and many people in this room were involved in that and know about it. But I thought it'd be helpful to step back a little bit to talk about the genesis of that article, and doing so also talk about the process that Martin and I went through in drafting the guide to the ICDR arbitration rules, which is now in its second edition and is a collector's item, clearly available for sale in the lobby. And so that's right, mine's available to sign. So when we published the first edition back in 2011, we were working off what we called the 2003 version of the rules, which was actually the 2003 version, which had been amended in 2006, 2008, and 2010, but there'd been the largest amendment in 2003. And the genesis for the confidentiality provisions was, and for many of the provisions in the rules, was the Untitled rules. We used as sort of the guiding backbone of the international rules. And there's sort of the two aspects to confidentiality, one of which is not directly important to what we're talking about today. One of them is confidentiality in the context of arbitration proceedings in general, what happens to information that is disclosed in the course of those proceedings. And that provision was addressed in what was then Article 34, dealing with confidentiality and also privacy of the arbitration hearing, which is another topic. The topic we're talking about today was addressed in Article 27, 27.4 and 27.8. 27.4 said quite simply, an award may be made public only with the consent of the parties or as required by law, which is pretty much what the Untitled rules say. And then there was an addition to that, what was Article 27.8, saying that unless otherwise agreed by the parties, the ICDR may publish decisions that have been redacted to conceal the names of the parties or other identifying details, or if publicly available. And so that was the sort of the two-part issue. An award is confidential, award may not be made public without consent of the parties, except in limited circumstances such as required by law. Or secondly, the ICDR may publish decisions that have been redacted or being redacted, or if it's publicly available, unless otherwise agreed by the parties. And so when Martin and I were drafting the first edition of the book, with respect to awards or decisions or rulings that we wanted to cite to in the book. It was a hard job. We didn't have Jus Mundi to rely on. We would, there were some awards, decisions, or rulings that were in the public domain that we were able to access. There were some we just knew about through what you talk about at cocktail parties, and you'd ask for someone for a for a copy that you then refer to, without revealing any information. There was knowing that reading in GAR or some other highly reliable source, there had been some case that was now in proceedings in court, and then working backwards the old-fashioned way on pacer, finding the case, finding the docket, finding the underlying award. And so we went through that process in a admittedly somewhat ad hoc way, because we didn't have the tools that are available today to carry that out. And I should have said, sorry, the fourth source, of course, was the awards that were available in redacted form in the Grant Hanessian's collection of awards that were published on an intermittent basis. So those were the main sources of information. Then just to upset our sales of the book, the ICDR amended the rules in 2014 and moved those two articles I referred to before to Articles 34 and 37. There was some tweaking of the language to make it clearer about when consent was required and when not. There was some language tweaked to address the change in the Untitled rules in 2010. But the basic task, or the basic division of responsibilities remained the same. Fast forward now to 2021 to Article 40, and a couple of things worth mentioning. One is that all the confidentiality provisions that were split the two articles before are now in Article 40. So Article 41 and 40 sub 1 and 40 sub 2 address confidentiality in proceedings. And then Article 40 sub 3 and sub 4 address the awards issue. And so Article 40 sub 3 says an award may be made public only with the consent of all parties or as required by law, except that the administrator, that is the ICDR, may publish or otherwise make publicly available selected awards, orders, decisions, and rulings that have become public in the course of enforcement or otherwise. And then sub 4 addresses the other part of the awards issue and saying that the ICDR may also publish selected awards, etc., that have been edited to conceal the names of the parties and other identifying details, unless a party is objected in writing to publication within 6 months from the date of the award. So the consent provision has had some structure put around it, that there's a 6-month period within which to make that objection. I think at some point on the panel we talk a little bit about how that works in practice, but that's basically how we came up with how Article 40 looks today. And the last thing I'll say is that that amendment takes place amongst sort of some global changes, both in underlying national arbitration laws, and we might have time to talk about that a bit later in the panel, and then also various institutional rules, where other institutions have both created a specific obligation on the parties, the arbitrators and the institutions, to keep awards confidential, but also at the same time acknowledge publication of awards with parties' consent, or where they're already in the public domain. And in that respect, the ICDR is very much in the mainstream of what they're doing now. And the last thing I'll say is, if you're looking to where the future might go with institutional rules, in what I think is the very different context of investor-state arbitration, the exit arbitration rules just came into force, the 2022 rules, and that has a more complicated regime, I guess, as to what constitutes consent for publishing awards, where there's basically a deemed consent to publish, and if you're unable to get consent, by default, the parties have consented to publication of a redacted or excerpted version of that award. So that may be where the future is going, at least in that area. With that, I'll stop.
Excellent. Thank you for that summary. So in practice, the question is, we've seen history of our rule, how awards are perhaps going to be available more broadly in the future. But why and how? In the panel members' roles as a party or an advocate, are they actually using awards? What are they doing currently? And Wendy, why don't you start
Sure.
us off with that?
My practice is primarily in the construction space. I am both an advocate and an arbitrator. I'm a mega projects arbitrator for the AAA as well as an ICDR arbitrator. It seems like most of my engagements are actually through the ICDR, interestingly enough. But as an advocate, I still try a lot of international arbitrations arising out of construction projects. So why do I look for awards? I will often look to see how arbitrators that I'm using, if they've considered a similar issue, often procedural, by the way, less substantive. Again, because they don't have precedential value, not truly. And construction law tends to be quite well developed in whatever jurisdiction is controlling for the substantive law. But for example, recently I had an issue where that there was a Calderbank offer. And the arbitrators who were it was an ICDR case, the 3 arbitrators had never seen one before and didn't know what to do with it, frankly, and looked to the parties to explain it. And I said, well, of course, I have all these treatises I can point to, but let me see if there's awards out there where arbitrators actually talked about how they were going to deal with that issue. And I was able to find a number of them. I'm just using that as for example. And other types of procedural issues where, you don't want to simply point to a treatise. You want to give a real life example of how a procedural matter was decided. In addition, a lot of my clients and opposing parties tend to be multinational corporations who have been involved in other international arbitration proceedings. I want to see how they fared in those other proceedings because I might be able to use that in some way if they have a pattern of practice of acting in a particular way. And then, of course, for experts, how experts fared and how their testimony was received by an arbitration panel can also be useful. I mean, there are some very public situations where a particular expert was absolutely lambasted by an arbitral tribunal, and then the decision became public, and that can be extremely embarrassing and useful on cross-examination to utilize that against the expert if they didn't do so well. So those are some of my experiences.
A number of uses. Bill, from the in-house perspective.
Yeah, absolutely.
Of course.
I also have a perspective of party representative. For like your situation, my business is advertising and marketing, so as the party representative. And we actually don't have a lot of repeat issues, and each issue tends to be its own unique thing. So the idea of going to arbitral awards for precedential value doesn't really have a lot of resonance for me. I'm not expecting to find my particular issue. Our issue is a general issue of contract construction. It's not something that how do you deal with this particular patent application, this particular business. It's very, very, each case will be individual. So, but what we do think that this is really important is in the selection process. And I've always been a big advocate of using the tools in picking your arbitrator. I think that is something that a lot of people, even today, don't really focus on. The number of times where there's not interviewing of the arbitrator, real opportunity to sort of ask questions and get a sense as to what type of person are you, what's your process, what's your thought process. Doesn't happen a lot. I'm conscious of that and really like to do that when I'm in the selection process. As far as awards, though, it's really interesting. I sort of do, my heart goes back to the era when arbitration was always just fast and much cheaper and private, and you didn't expect to get information on an arbitrator, but you did expect that you could pick an arbitrator based on their experience who would probably give you a better result. And I now, actually what changed my view was prior obviously to this discussion, I found one of my awards, just stumbled across it on a Google search one day. I said, oh my God, look at this. And it was, I was proud of the award. It was great. But I realized, and that because as an arbitrator, I had always thought of the finality of my role. Once that award is issued, the case is out of my head. I'm not thinking at all about what happens to the case. The parties are free to go and do what they want to do. So that there'd be some subsequent history to my case that would be available for me on a Google search was shocking. And then it was like, oh, this is quite an opportunity. So now that's standard process. I mean, we'll be looking at this even more closely as it develops. I mean, I do see us sort of on a trajectory where this is something that will develop over time. There'll be a lot more information a year from now than there is today, and there's a lot more information today than there was a year ago. But that's going to be part of our standard process of looking at it. And again, not looking at it in terms of like precedential value, looking at it in terms of I want to understand the logic, I want to understand the thought process. How does this arbitrator approach? How does this arbitrator express the ultimate issue of the award? What is it reasonable? Is it clear, reasoned, well thought, well written? That's the type of thing that we're looking for in combination with the analysis in general of the background of the arbitrator. And ultimately, always comes down, I've said this at another gathering, from the party's perspective, I just want to win, right? That's always, we'll do what we need to do, but our first goal is to win. As an arbitrator, we're invested in sort of a lot of the issues, the legal issues, and the novelty of approaches. But really, as a party, I just want to make sure that I pick a person, we're going to win the case, and I can go back to my superiors and say, we did well, and it's a great result. So, but yeah, I see tremendous application for this in the party, in the arbitrator selection process. And 10 years from now, I'm sure I'll be saying that I'll see tremendous progress in terms of the precedential value, to the extent that that's a relevant issue for our entities.
And just to clarify, so you're saying you usually can find something about a potential arbitrator in terms of an award, an order, something.
It depends. I mean, there's more often than not, no. But certainly an arbitrator who's done a lot of, handled a lot of matters, there's invariably going to be something out there. So if we have a smaller matter, and a lot of our matters are a feature of contract. We often don't have the leverage in our contracting, so our clients will determine whether there's an arbitration clause or not. If it's a smaller matter and there's an arbitrator, you probably will not find anything. But on big disputes, there often is that one or two cases. I don't need to have like every case the arbitrator ever wrote. Just a couple of examples is perfect as part of that process of evaluation.
Great. Martin, what are your thoughts?
I mean, user comfort is obviously, I think, what drives the research project when it comes to what arbitrators have ruled in awards. In terms of precedential value, I think it's important to remember that there's always the law, and under certain institutional rules, there's also the industry customs and trade practices. And I think for that purpose, an in-depth research into available awards can be extremely helpful, because some, especially in the energy industry, disputes turn on one word used in contracts, in which case it would be very helpful to know how different tribunals have interpreted it and applied it to underlying fact patterns. So industry custom is something where I recommend highly to spend some time in researching awards in depth, and it lends itself to research project as well as educational projects. And in the energy industry, I was fortunate enough to work with the ICDR on an oil and gas joint operating agreements research paper, where we had access to certain ICDR awards that then helped interpret standard contracts used in the oil and gas industry. So there are some of these kind of fields where I think tremendous value, in addition to comfort, can actually be gained.
Eric, maybe I can give a few figures on what we discussed. First, we have 6 of your awards, William, available at Jus Mundi. The most recent is a case between Richmond Event and Ritz-Carlton Hotel Company in 2021.
I remember it well.
We discussed, Eric, you were right to recall that a lot of the ICDR awards are already out there. We have more than 600 ICDR awards that we have been collecting already on Jus Mundi, and more than 1,000 from AAA also. In total, that's approximately 4,000 commercial arbitration awards that we've been able to collect. And interestingly, more than 50% of these 4,000 awards have been rendered in the past 5 years. So indeed, it will increase now. For the recent years, we are able to identify almost 15% of the international commercial arbitration awards that are rendered. So in 10 years, it might be very different indeed.
Jeremy, all those awards, they're not obtained for the most part from the parties. You're getting them from publicly available sources, or maybe you can explain how you do obtain those documents.
So it's mostly through enforcement or set-aside proceedings all over the world, or sometimes it is leaked into some newspaper. So also to clarify, non-arbitrator is leaking awards directly to us. In the case of Aleximo, for instance, he just informed get some information on cases that were not confidential that we verified. But we do not accept a contribution from someone that is anonymous if the contribution is an award, because we want to know that, okay, it has been leaked by this person. But a lot is leaked into newspaper.
But you will reach out to parties sometimes directly, right? And ask if they can make information available or an award, or
we only reach out to parties or arbitrators to confirm information that we receive on cases, to ask them if this is true. But otherwise, we don't actively contact parties to get information. Lawyers, yes, but information that is publicly available. Yeah.
James, you have some?
Actually, I had a question. I mean, given that it's much more common in the US litigation system to have these awards available through the enforcement or setting aside process, does that not skew the data set somewhere or somewhat?
It totally does. I think, I don't know exactly the statistic, but I would say that 15 or 20% of our commercial arbitration cases are New York law. It's because we collect a lot in the US.
Do you know the percentage of cases
Of commercial arbitration
from the
cases?
US? Yeah. From the US court system?
Yeah, I mean, also using a US of a New York law inside the contract. So it comes mostly from the US, but also because that's one of the first jurisdictions that we targeted. Now we are focusing a lot, for instance, on Asia, on Latin America, and there are several countries in which you can find the award, like in Brazil, for instance. So it's possible to find a lot of the awards in courts.
Do you have direct access to the ECF filing systems? So the moment such a motion is filed, you will get notifications within your database? Yeah,
we're able to if you see the most recent documents on Jus Mundi, you see a lot of them. So it gives you also strategic information on cases to know that there is an enforcement proceeding.
That's how I learned how one of my awards connected to the court on Jus Mundi.
You can have now we are making an evolution. So when you claim your profile and you enrich it, you can get automatic alert on yourself. So if there is a new case, you know about it.
There's another aspect of who uses these awards, which it's not really what I do, but we've seen it, which is the award enforcement and the third-party funders and those entities, which have been quite sophisticated in that space for a long time. I'm not sure if they're users of your system or competitors, but they have similar.
So third-party funders are users. They ask us to collect many more enforcement cases, and they want us to build some statistics on enforcement per jurisdiction. So that's something we are working on. It will take a bit of time to do it.
James, I didn't know if you had any other.
I guess the only other thing I was going to raise in terms of the utility of the awards or orders is, I think in the procedural sphere, it's particularly important. And I've always been a big advocate for institutions sort of taking the lead on that in terms of tricky issues to do with joinder and consolidation and third-party interveners and challenges to arbitrators and those things which are just, no one's going to say it's a precedent, but at the same time, it's a useful contribution to making the system more predictable.
So it seems, at least on this question, why would parties and their advocates want to obtain awards? We're hearing a lot about arbitrator selection. It's useful in that regard. It can also be used certainly to educate the tribunal. Just talking about the trade usage, customs, things like that. We might be dealing with something that's relatively unique. Not a lot of, I didn't hear a lot of, maybe we'll get into this a little bit more, but in terms of precedential value, it's not one of the primary reasons, but I'm certainly hearing that
if something explains an issue in a case that goes one of the parties' ways, they're going to be more than happy to perhaps share that decision with, find a way to share that award with the tribunal nonetheless. So very interesting. And then perhaps in a different context, as arbitrators, how does the publication of awards or the potential publication of an award impact you as an arbitrator? Hopefully not in terms of outcomes. Shouldn't be pressured because an award is going to be perceived a certain way. But does it impact how you write it? Does it impact what the parties say to you about what they want or expect in an award? So again, a number of different considerations there, depending on your role. And Bill, do you want to share with us? You touched on some of this, but do you want to give us your thought when you're an arbitrator thinking about writing an award? Does its potential publication impact?
The short answer is no, it doesn't, because there's basically three main audiences for every award that I ever write. One, at least in terms, I mean, there's many, but in terms of my thought process, there's three that I'm most concerned about. One is the losing party. So I always draft an award so that the loser understands exactly what happened in the process and can, if not love the process, buy into it, accept it, understand that they were heard, and there was a reasonable basis for the decision that came out. The second audience is some judge who is dealing with a confirmation issue or some dispute, some challenge. I'm drafting the award for that judge. When there's discretion, something that's within my discretion, I want to make that crystal clear that I used my discretion, the evidence. I mean, I write that specifically for the judge to aid them, him or her, as that decision-making process is undertaken by the court. And then with respect to this whole notion of confidentiality of awards, understanding that there are different entities that will, constituencies that will see the award, and I really don't know what's going to happen to that award after I sign it and turn it over to the administration, the administering entity. The last entity is the New York Times. I use that broadly, but I don't sign my name to anything that I wouldn't expect to see on the front page of the New York Times. None of the decisions that I have rendered would be newsworthy enough to make the front page of the New York Times, but it's still, I use it as a guide that there's always a chance this document will be a part of the record, and I'll see it, I'll stumble across it one day, and oh, that's really interesting, and I want to be proud of that and happy with the process. So yeah, nothing changes. I mean, if I've never expected that the award was just for the parties, even though they've agreed to confidentiality and nothing's supposed to get out. And I've always understood that there was a possibility for that to go beyond, and always wanted my award to be able to withstand.
James?
I agree with everything Bill just said, and for me, the primary duty is to create an award that is as enforceable as possible. So your job is to make sure that the award is framed in a way that should it end up in the court, whether it's publicly disclosed or not, it's going to withstand the scrutiny process. I guess the only thing I'd say on this topic is even with publication of awards, I guess it wouldn't change the way I draft an award, but I guess a concern would be that if we look to the investor state world, some would say that that system has become overburdened with arbitrators who use this as an opportunity to advertise their services and to draft erudite, war and peace versions of awards that don't need to be that detailed. I guess that's a risk that one would take in the system, but one certainly wouldn't. To me, there's an obvious downside. The flip side of that is that I don't know that I want to appoint an arbitrator that's written war and peace on a $500,000 dispute over who's going to pay for some lumber. But those are two thoughts.
Yeah. Martin, did you have anything on this?
Yeah, it's. I might not go with the mainstream with this, but when I look at an arbitration and then sitting as an arbitrator and having to decide the case, I really look at it as there's two or more parties that have a dispute. I mean, if I want to write a book, I write a book, and then my wife has to, at some point, hopefully be able to buy, sunflowers with the royalties that come from that book.
Small flowers.
I mean, Ms. Hosking might have an opinion on that too. But the point is, it's really a dispute. And at the time of deciding a dispute, it's the users of the system that you write for. And I think in our pre-calls, I always stress the point of being an emergency arbitrator, especially at that point. I think that, might be as important as, making sure the decision is enforceable. And that is that, this is an early dispute amongst two parties that, where side claims there's an emergency. And that will also depend on the likelihood of success on the merits going down the road. So when deciding the issue, you might actually elaborate more this dispute is about than under a pure perspective of I do my minimum and provide less field of attack in subsequent enforcement proceedings. Ideally, you serve all purposes.
Monday, did you have any?
No, I echo everything that they all said. I'm not going to draft my award any different. I also ascribe to the, if you wouldn't want to see it on the front page of the New York Times, don't write it. And I often tell my clients exactly that, particularly when they write emails. But no, I echo all that. If I know an award is going to be utilized and made public, not so much to the public at large, but potentially utilized in another context, I might frame my award slightly differently. In the construction space, sometimes we find that a contractor is going to then use that award in a downstream proceeding, for example. I might frame it a little differently if I know it's going to be utilized in that fashion and will be, available for that purpose. But other than that, not generally, no.
Can I add one thing? Sorry, Eric, just occurs to me. I guess one thing that could be different is it makes the confidentiality provision in the agreement or sensitivities around data protection all the more important if there's a realistic prospect that the award is going to see the light of day. In the investor state sphere, for example, and we have had cases where it's as transparent as it can possibly be. We even have public hearings, but there is confidential information that cannot be disclosed, and there are special procedures then that are also put in place for the awards. The award is actually produced in a redacted form, an unredacted form, and hopefully the unredacted form never sees the light of day.
On investor state, I'm sorry to chime in, but I remember the days when we did dozens of cases literally against Argentina, and obviously with the firm Hawking and Spalding at the time, which was at the forefront of that initiative, I think. And I remember we stressed heavily that we were challenging individual government measures as opposed to Argentina's policies when it came to their ways of addressing the so-called economic emergency that they attempted to address. And I believe that over time, and maybe because of the lack of confidentiality of awards in the investor state field, this political issue has been played up. What I'm talking about dates back now 15 years or so in the early cases against Argentina. And since then, we have seen attempts to overhaul an entire legislative endeavor and goals, such I think Philip Morris v. Australia and such examples. So the nature of the case, the nature of the dispute has changed. I think publicity doesn't always lend itself as a very helpful tool to resolution of an individual dispute where an investor has lost money.
Wendy, this might go back to the topic of serving more as counsel, but you in a prior discussion were saying that you've really seen a trend towards raising the issues of confidentiality, particularly because of increased perhaps concerns or issues of publication of outcomes awards. It's being affirmatively taken up early in your cases.
Yes.
So
Again,
not waiting until the award, but saying right up front.
And I should say, a lot of cases I handle, we have international rules and there's this belief among some that that's inherently confidential, that everything is inherently confidential. And I said, not so. And we need, if we want it to be so, we need to make sure we write that into our rules, our procedural order. And I have lots of fights about that because I will generally seek confidentiality. And that's just my kind of mindset. I will ask the opposing party to agree to confidentiality upfront for everything that's exchanged. Witness statements, procedural orders, any memorials, briefs, et cetera, that are submitted. I want to make sure that they're confidential. People fight me on that all the time. And why do they do that? Because oftentimes they perceive that they want to leverage me in some way. A lot of my disputes, I'm the monkey in the middle. On construction projects, I have the general contractor. I'm fighting upstream battles, I'm fighting downstream battles. The last one I had, 6 international arbitrations came out of one power project. Yes, it was a lawyer's dream, okay? 3 of them went to full hearing and award. And that took 5 years, right? But the opposing side wanted to use the submissions from other proceedings against me, perceiving that I would be talking out both sides of my mouth. And so that was a big battle, and each of these separate tribunals had to deal with that. But we did tee it up upfront so that we knew the ground rules at the beginning. And so we had that decided. I would, and still we had disputes at the tail end as to confidentiality issues in subsequent proceedings. So, but it is important to deal with that upfront and get it resolved to the extent possible upfront, so that everybody is operating with the same ground rules.
You're seeing that as a change in practice in more recent.
Absolutely.
I'm just going to pause here and make sure there's no questions from any of you at this point, or we.
Question, it's a 2-part question for you, I think. When in the situation where the parties haven't agreed on publication, and the ICDR is going to do it with redactions, do you submit it to the parties after you redacted it as a sort of double check? And the other part of the question is, have you gotten blowback from any of the publications you've done from the parties?
Not in the international context. There have been some parties that have raised concern about some other words that had been published, and we dealt with that. In terms of international words, if there's just a blanket objection and they're affirmatively saying, don't publish our award, we're not going to do that.
So what would be the in-between case where they haven't agreed, but they're not obstreperously objecting to it either?
Well, if they're not responsive now,
Okay.
really, I mean, if they're not responsive to our requests, that's now going to be deemed to be an agreement, and they will. So that word might be published in a redacted form. So that's the way that we plan on having that work. But we want to make sure we want to do this responsibly. We don't want parties to be surprised if we're going to be publishing something of theirs.
Eric, one aspect of ICDR arbitration that continues to be opaque is the Administrative Review Council on challenges to arbitrators. And in Jus Mundi, I haven't seen any. I don't think the ICDR actually issues opinions with reasons. I think they even say that it's not. Is there any talk about opening that up to the public?
Yeah, just so everybody understands, we're talking about issues regarding arbitrator disclosure and request to disqualify an arbitrator because of conflict of interest, or at the preliminary stage. I'm reluctant to call it arbitrability, but the demand for arbitration is filed. Respondent says there's no agreement to arbitrate whatsoever. AAA, you've got to suspend. And so this is this is an administrative body, internal staff plus a former executive of the AAA who's on every panel that decides these things. And so that's right. They'll make decisions. Arbitrator is confirmed, or filing requirements have not been met, and they're not reasoned. In terms of the first issue would be to set up sort of the apparatus to create awards decisions on those administrative procedural issues that we're deciding. And I'd like to do that. There are some real roadblocks. I know other institutions have panels in place that do it, but you got to do them quickly. And again, we're not looking to invite additional challenge other than what's permitted. And we've had that. We've had staff reluctant to say subpoenaed. We're not looking to compound problems that are already difficult, things like disclosure and the like. So, I'd like to be able to do that, but I can't say that there's anything in the works to publish that. And then it would be, if we do publish something, where do we do it? Where does it appear? Is it even made available to anybody other than parties? No, is it, I mean, so, it would be get the same circumstance, is it just made available to parties or not?
So, Rick, if I can, since we've launched the conflict checker on Jus Mundi, we've seen an increase in the number of challenges to arbitrators. We've even seen counsel going to the hearing using conflict checker in live, saying like, "Look, you're conflicted." So we had this, and we had a number of requests from counsel arbitrators to have more decision on challenges, so it can help to set the standard to avoid abusive challenges. So this is a need that we hear, and as far as the ICDR is concerned, we've been able to find 3 decision on challenges at the moment. So maybe there will be more one day. See.
Interesting. I'll have to look at those. Surprises me. Okay. Other questions? One other topic. Again, this has come up a little bit, but the issue of a precedent. And I was struck by Jus Mundi's statement. Why Jus Mundi? And one of the statements is building the global rule of law. That's a very, that's an important statement. That's creating a sense of a global rule of law. Are we going to have that at one point? Is that a natural consequence of everything that we're talking about today? More narrowly, the issue of precedent. Will that become something the parties and arbitrators can or are expected to rely on? Should they be relying on other arbitrators' decisions as precedent? And then another, again, earlier conversations as we were talking about it before today, this issue of sort of foundational decisions. Are we going to have that in arbitration where certain outcomes, certain decisions are going to be found to be held to be foundational among our community? So I'll just throw that one open. Does anybody have any thoughts about precedent in the sort of more immediate sense? Is it appropriate? Should we do that? Should we not do that? For an arbitrator, do you look at awards? Will you consider them? And are we headed towards a global rule? Anybody? Just think about the first question. It's a bit easier.
Have you taken the last one? I mean, are we headed to a situation where there's all this information and people are using decisions and looking at precedent and arguing that in their cases? Yeah, I think that's absolutely where we're heading. I mean, I think arbitration has been moving over time from its, the notion of, as I was saying earlier, that it's a private, simple, not simple, private, effective, fast, cheap way of dealing with disputes, to there's an understanding of counsel and the parties and arbitrators that that's not necessarily what people are looking for all the time. There's much more of a litigation of the process, I think. I'm making up a word there, but where there's an expectation of all of the benefits I get in when I go to a court, with like all of the procedural safeguards and all the tools and devices that I can use there, I should be able to argue that I can use that in arbitration. And I think that there are many of us who are resistant to that, but again, then we're stuck with the fact this is a party controlled process, and the whole notion of arbitration is that, I think its single, probably biggest selling point is that they are the ones that craft this. And so if they choose to craft something that looks a lot like a court proceeding, I don't know what there's much that we can do as arbitrators to stop that if that's what they really want to do. But yeah, precedent, absolutely. And as an arbitrator, I've had it happen a few times where prior arbitral decisions have come up as part of the argument, where there may have been related proceedings before it came to me, and they were citing to those. Sometimes saying, and again, you have to look at that for give it the weight that you think it's due. And sometimes it is a little where it's very close and it has some value. I'll consider it. It's part of the analysis that goes into the decision-making process. Other times it's clearly not relevant, and I don't. I've had my own award cited to me in another case once.
How'd that go down?
That's very interesting. I think they miscited and misused it, so I didn't really help them, but I thought that was very interesting. So yeah, I do think that that's the future where there's a greater reliance. I mean, I advocated moments ago the importance of doing this for arbitrator selection, but not necessarily for precedential value. But again, I mean, years from now we'll be in a different situation. When as any lawyer that's contemplating getting into a dispute, you want as much information as you can. And if there's decisions out there from an arbitrator or panel of arbitrators, and I can use that as part of the process of handicapping what my chances are of winning, should I settle this case or should I proceed? Well, who's not going to use that? So I think it's a little shocking now for us to think of a world where you just type in, do a Alexa search and you pull up all the arbitration decisions, and your brief cites nothing but prior arbitration decisions, as distinguished arbitrator so-and-so argued, and but I think we are going to get there, and I think the parties are going to want that. I think counsel are going to want that, and as long as it aids our job as arbitrators in coming up with fair results, we think the process is fair. I think that we're going to rely on it just as easily as it's available. My view. I don't know if anyone disagrees with that.
I would distinguish between substantive precedent and procedural precedent. I don't know about you, the first ICC arbitration I ever handled, I was dealing with a bunch of English solicitors on the other side who thought, the stupid American doesn't know how we do it over here. And this is the way we do it in London, and you don't know what you're talking about. And so I promptly bought, Craig Park and Paulson on international ICC arbitration to figure out how do they do it, right? And then you come to find out that's not how people do it at all, right? They just made it up. And so there's a lot, because the rules are not the picture of clarity, right? They're not particularly detailed, and a lot of it is custom and practice. And so when you find yourself in a procedural dispute, for example, I was recently arguing about third-party subpoenas in an international arbitration where the other side wanted to issue 25 subpoenas for documents that I had already produced to them, but they wanted to make sure they had gotten everything. And fortunately, I was able to pull out some precedents, some arbitral decisions on that very subject and say, no. Third-party subpoenas should be strongly disfavored in international arbitration, and certainly not for the purpose of testing whether you got everything from the other side. And so that was very compelling to utilize it in that fashion. So I could certainly see awards and procedural orders, to the extent that they're made public, being utilized in procedural battles to show what the custom and practice is in international arbitration and what's perhaps bad form.
James, were you gonna?
I was just a very, very similar point. I haven't signed on to the brave new world of arbitration awards as precedents, except in narrow areas, and you can call it procedural. Or, I was trying to think of some examples where I've seen them cited where they were actually somewhat persuasive or useful, and the ones I jotted down were awards interpreting the IBA rules. That's somewhat useful. I'm not binding in any way, but it's some value. I had an interesting case under the old version of the AIPN joint operating agreement, where there was one particular award draft, where one of the arbitrators was also one of the people on the drafting committee of the AIPN, and that award keeps coming up time and time again. And so I think that's something where it's not precedential, but it had sort of an added value to it or a greater weight. And what I saw recently for the first time was, I won't mention any names, but a firm that cited an award in another case as to the reasonableness of their costs, which I thought was interesting. But outside sort of those narrow areas and important areas, I don't think awards or orders should enormous weight described.
And James, I also want to touch on one thing you had mentioned before. You talked about legislation actually impacting arbitration awards, international arbitration awards, or
Sure. So
certain
um,
countries are taking this up as a legislative issue.
yeah, and to give a very high level overview, confidentiality and arbitration is something that various jurisdictions have legislated. When I say confidentiality, some of it extends to the arbitration process itself and the documents and the filings and the evidence that's produced in the arbitration. With respect to awards, certain jurisdictions like I think I'm right in saying Singapore, Australia, and India have passed legislation where the parties are under an obligation to keep the award confidential. And then on top of that, in certain jurisdictions like Singapore, there are specific procedures in place in the court system so that if you challenge an award or enforce an award, there's actually a presumption that the not only can the award be put on the file, but not only will the award be searchable on the file for the public, but also that the hearing itself will be held in camera, or there'll be extra protections put in place. And the reason I know that little bit, which hopefully is right, is because someone tried to pass similar legislation in New Zealand, my home country of New Zealand recently, and that brought out the whole transparency versus confidentiality debate. It ended up becoming what people thought was going to be a very obscure issue, became briefly of something of public debate. And ultimately the forces of transparency prevailed. And so there is no legislation in New Zealand on the confidentiality of awards.
Eric, just a comment on this. In my research leading up to today's event, I also looked through some of the legislation, which is then the interesting approach to attach to the arbitral proceedings as such, as opposed to institutional rules that usually address the arbitral tribunal, and then the secretariats and staffs that handle that matter, and maybe the parties. But in my German-speaking origin, interestingly, the rules also address witnesses. And I thought that was kind of unique, then because the witness testifying at what is perceived to be a private hearing is only subject to the confidentiality of the underlying proceeding if the parties that nominated them have had them agree to it, or they're affiliated with the parties and as such bound by the confidentiality. But that's one can be leaked legitimately.
Blame the experts.
And indeed, witnesses include expert witnesses. I mean, this is not only fact witnesses.
Okay, moment for questions.
I'm curious as to dissents.
Dissent? So we have three big categories of documents on Jus Mundi when it comes to case law. We have all the decisions award, the main procedural orders that are categorized by type of procedural orders. We have all the dissenting opinions, and then we have all the procedural documents. So we mentioned experts. One of the use cases is finding former expert reports to point inconsistency between positions. And so we have a number of dissents that are available on the platform linked to the arbitrator as well. And I do confirm that most of our clients in commercial arbitration, they use this award for procedural issues mainly. I always test like, oh, you should use it also for merits. And the answer I get most of the time is that I'm not sure I will be able to find awards very relevant. So I think this part will develop. But clearly for now, it's mostly on procedural issues that people are using us in commercial arbitration.
Excellent. Well, please join me in thanking the panel. Really very thoughtful, expert. For reception, cocktail in the cafeteria. Thank you.